Hello, gorgeous people. I'm Hayley Bound, founder of The Caring Lawyer, helping new lovers protect their assets. I'm a relationship property lawyer specialising in contracting out agreements, or also known as prenups. Today's question is, my ex has spent our joint money on drugs, gambling, and affairs. Can I get more than 50% of our relationship property? Because our relationship is over and I should get more. Yeah, I can actually understand why you would want to get more than 50%. It's so unfair that he or she has spent your money in this way. Honestly, it is unfair. And surely you should be able to get this back when you separate. You would think so, because that just seems so unfair that you wouldn't be able to. But unfortunately, in New Zealand, relationship property law, it has no fault system. So we've got this no fault system. So generally speaking, you would not be entitled to 50%, to more than 50%, even when the ex has behaved terribly, which sounds so unfair, I know. However, there are circumstances where unequal division has been considered appropriate. So I'll talk about that now. It's not legal advice, obviously. It's just to give you an overview, a general overview of what the law says. So Section 13 of the Property Relationships Act 1976, from now on I'll just call it the Act, provides for an exception to equal sharing where there are exceptional circumstances. In 2016, a High Court case called Bowden and Bowden drastically deviated from the equal sharing rule by giving 80% to the deceased husband's estate and 20% to the surviving spouse based on these extraordinary circumstances. So he'd passed away and his estate got 80% of the relationship property, and she, the wife, the surviving spouse, got 20%, which is drastically different. So Section 13 of the Act is a notoriously stringent test, and successful applications are actually quite rare. Not impossible though, because we've seen in Bowden and Bowden it can happen, but difficult. So when deciding on whether to deviate from equal sharing, courts consider three things. They consider, are there extraordinary circumstances, first of all, and then do those extraordinary circumstances make equal sharing repugnant to justice? And then they look at, what should the division be considering the parties' contributions? So you might consider that spending joint money on drugs, gambling and affairs is an extraordinary circumstance that makes equal sharing repugnant to justice. Yet, there are cases where these circumstances have not been considered extraordinary. So that might seem really unfair. In one case, Joseph and Johansson in 1993, Judge Richardson held that the test is not to make an assessment against some kind of marriage norm, but rather to consider whether tested against the whole range of marriages, the particular circumstances are to be characterised as ordinary. So I guess spending money on drugs or affairs is normal? I don't know. It doesn't seem fair, but the reality is spending joint money on drugs or affairs on its own is not considered extraordinary. Although I think it probably is, in my personal opinion, but not for the courts. So if that was all that they had done on their own, then it wouldn't be enough to say that you should get more than 50% of the relationship property. So under Section 13 of the Act, successful cases can be categorised into 5 kinds. The first kind is injection of capital. For example, in one case, the husband received a huge inheritance and then used that money to pay off the home loan on the family home. And then not long after the relationship ended. Here the court considered that was an extraordinary circumstance that makes it the equal sharing repugnant to justice. It would be so unfair if the inheritance was divided equally. And also keep in mind that the relationship ended, if the relationship had ended years later, it would have actually been a completely different outcome. So if you are wanting to keep your inheritance safe from relationship property, I recommend a contracting out agreement, especially if you're thinking to put that inheritance into your family home, because usually, regardless of where that money's come from, it's going to be divided equally. So yes, I definitely get a contracting out agreement if you're going to do that. The other thing that courts look at is the brevity of the relationship. So the longer a relationship lasts, the more difficult it will find exceptional circumstances. In one case, over $200,000 was injected into the relationship property near the end of the relationship. In this case, the claim failed because the relationship was 22 years. So that's what I just said before. Basically, if you're going to inject a whole lot of your inheritance into your family home, get a prenup, because if your relationship is longer than 3 years, it will just become 50%. However, in other cases where couples have been together for long periods, courts have given unequal division, so it really does depend on the circumstances. The other thing that courts look at is gross disparity of contributions. Contributions is actually a really tricky one, because automatically we think in terms of money. I gave more money towards purchasing the house, therefore I've contributed more to the relationship property. That's how we normally think, especially if you bought the whole house by yourself and your partner didn't contribute at all financially to it. But actually courts don't see contributions in that way. Contributions also include non-financial contributions, such as taking care of your spouse or your children, doing the housework. In one case, the husband had purchased the family home prior to the relationship even beginning. The wife didn't work, and the relationship was not much longer than 3 years. Yet the court gave equal division of the family home because she had contributed to the relationship by looking after him. He was very, very sick, and she looked after him until he passed away. So the court said that was her contribution to the family home. By looking after him, she contributed equally, and so she was given equal amount of the family home, and his estate was given the other. The other things that courts will look at is the non-contributing partner. There are two cases. Bevan and Bevan is one of them, and Johansson and Joseph is another. Both cases include husbands that spent income on alcohol and gambling and did not support their families in any way. So they basically left their wives and children to defend for themselves. And the courts held that this was extraordinary circumstances, making that equal division repugnant to justice. Yeah, I know. I just said, if your ex is spending money on drugs and affairs and gambling, that you couldn't claim for more than 50% of the relationship property. Yeah, I know. I just said that. I know. And that is still true, because that on its own is not sufficient to meet the high threshold. In these cases, the husbands left their families and didn't contribute at all or support them in any other way. So if your husband is still helping to pay the mortgage, let's just say you've separated and you're living in the house and your ex-husband is still taking is still looking after the mortgage and helping you, then that's, the fact that they spent money on gambling and affairs isn't going to be enough on its own. Because in this case, the husband spent all their money and didn't contribute in any way to help support the family. In another case, D&D it's called, the wife's mental illness required her to be in residential care for most of the couple's 24-year marriage. The court found that she contributed only 20% to the marriage partnership. So the court divided the relationship property accordingly by giving her 20% and the husband 80%. And it's a little bit sad for the wife. I feel for anyone who has had to go into residential care, especially for 24 years. It's quite sad that she's had such mental health issues, and it's not, that's sad. But I understand the unfairness for the husband. If I put myself in his shoes, it just wouldn't be fair if he didn't get what he'd put into it. Another thing that courts will look at is negative contributions. So contributing negatively to a relationship, such as deceit or broken promises, these can amount to extraordinary circumstances. In one case, the forgery of a wife's signature on loan documents was sufficient for the wife to successfully obtain a greater than 50% share. Well, fair enough. I mean, honestly, that's pretty rude, isn't it? Forging her signature so he could get a loan. All right, so now we've done extraordinary circumstances. The next is the test is for repugnant justice, and that test is just as notoriously stringent as the test for extraordinary circumstances. And many cases fail because the courts are not satisfied that equal sharing would be repugnant to justice, despite there being extraordinary circumstances. Courts look at the overall circumstances. So using joint money to have an affair, or using joint money for gambling is not sufficient on its own. So using joint money unfairly on its own is insufficient to hold that there should be unequal sharing. There would have to be more, such as a disparity of contributions and negative contributions. There has to be more to it than just that. But if successful, the courts will quantify the parties' contributions to the relationship to reach a just division. So one way to ensure that there is fair division at the end of a relationship is to have a contracting out agreement or a prenup that covers all of your concerns. And this will not only protect your assets, but will make life a lot easier if your relationship did end, because the agreement will have in place what is considered your separate property and how to divide the relationship property. And having this already set up and already in place avoids you having to hire a lawyer to negotiate a settlement, because an agreement was already made prior to your relationship ending. So if you want to know more, feel free to call me. My number is 07839 7632. That's 07839 7632. Or you can email me on hayley@ghslaw.co.nz. That's hayley@ghslaw.co.nz. And otherwise you can just Google. Google the Caring Lawyer and you will find me. So thanks guys, it's been great having a chat again. Thank you for your listening ears. Thank you. Feel free to put any comments, ask any more questions in the comments section, and I'll be happy to answer them. Thanks, bye.